Man, that Alex Jones fella just can't catch a break. He can't use a fake bankruptcy to avoid billions of dollars of awards to these Sandy Hook victims.
I have $130,000 under penalty of perjury. There's no hidden accounts. There's nothing in the Caymans. There's nothing, on the moon. There's nothing.
Yes, after years of spreading vicious lies and baseless conspiracy theories about the Sandy Hook massacre, Jones was found liable to the victims' families for $1.5 billion. But Jones thought he'd discovered that one weird trick to weasel out of paying the people he hurt, declaring bankruptcy.
I declare.
Nope, do not cut to that video, it's too easy. Yeah, except that a judge in Texas just shot down that effort, declaring that as a matter of law, at least $1 billion of Jones's judgment debts cannot be wiped away by bankruptcy. Why, oh why, do bad things very occasionally happen to bad people? So let's look at how Alex Jones tried to use bankruptcy law to avoid paying billions of dollars and why that effort failed so spectacularly. Now, if you want a more detailed account of Alex Jones and the Sandy Hook trials, you can check out some of this channel's other videos on the subject, including the video I did where I explained how attorney Mark Bankston absolutely destroyed Jones on cross-examination. But to quickly summarize, for years, Alex Jones described the 2012 Sandy Hook massacre as a hoax and part of a secret government plot to take your guns. Jones's lies unleashed a wave of harassment on the victims' families, who are very much real, triggering multiple civil lawsuits against him for defamation, intentional infliction of emotional distress, and other torts. In late 2022, a Connecticut jury awarded $965 million in compensatory damages and $473 million in punitive damages to the families of 26 people who were killed in the 2012 shooting, plus an FBI agent who was among the first responders. In August of 2022, a Texas jury found Jones liable for $4.2 million in compensatory damages and $45.2 million in punitive damages to Neil Heslin and Scarlett Lewis, whose 6-year-old son was killed at Sandy Hook. And before that, in October 2021, a Texas judge found Jones liable for defamation against Leonard Posner and ex-wife Veronique De La Rosa, whose 6-year-old son was also killed. The pair are still waiting for a trial on damages. In all three cases, the courts had entered default judgments against Jones based on repeated violations of discovery orders, resulting in Jones being adjudged liable on all causes of action without trial. Yeah, that's what we like to call here a huge FAFO alert. But Jones had made it clear that he had no intention of ever paying his victims, calling the damage awards hilarious, and telling his audience he plans to file appeals to keep the victims in court for years. Jones also claims he's officially out of money, having repeatedly begged his audience to send him money to keep him on the air. And to that effect, Free Speech Systems, Jones's company that runs InfoWars, declared bankruptcy in July 2022, and Jones filed for personal bankruptcy in December. And since many people's understanding of bankruptcy is limited to knowing that's how you lose at Monopoly, here's a quick explainer. Filing for bankruptcy provides a legal process for the reduction or elimination of certain debts. In bankruptcy court, parties' debts, including those incurred by court judgments, are categorized as either dischargeable or non-dischargeable, depending on how they were incurred. If the court deems a debt to be dischargeable, the debtor is no longer personally liable for the underlying debt and is excused from any obligation to pay. Common examples of dischargeable debts include credit card and medical debt. In contrast, non-dischargeable debts cannot be extinguished in bankruptcy, typically for public policy reasons. Section 523 of the Bankruptcy Code lists examples of non-dischargeable debts such as domestic support and tax obligations. Now, ultimately, Jones wants to have part or all of his $1.5 billion in judgments declared dischargeable, so he and his company no longer have to pay them. But to prevent Jones from erasing his judgment debts, the Sandy Hook plaintiffs formally intervened in the bankruptcy process. Now, of course, if you're ever hit with a $1.5 billion defamation judgment, you're gonna need a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've been in a car crash, dealt with sexual harassment, or suffered from cancer, we can represent you or help find you the right attorney who can. It's so important to talk to a lawyer early to make sure you get the maximum recovery and choose the right options. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. In March of 2023, the Sandy Hook plaintiffs from Connecticut and Texas filed 4 adversary complaints against Jones and Free Speech Systems in the bankruptcy court. In these complaints, Sandy Hook plaintiffs allege the judgment debts are non-dischargeable pursuant to the Bankruptcy Code section 523A6, which excludes from discharge any debt that was the result of a, quote, willful and malicious injury against another. The families and other critics believe that Jones is abusing the bankruptcy process to welch on his debts. And back in March, Jones was accused of transferring up to $10 million to friends and family members to put it beyond the reach of creditors. And contrary to Jones's newfound claims of poverty, an August 2023 court filing from the victims' families paints quite the opposite picture, detailing Jones's hundreds of thousands of dollars in lavish spending. So the Sandy Hook plaintiffs moved for summary judgment against Alex Jones to prevent the $1.5 billion in judgment debts from being discharged, i.e. expunged, through bankruptcy. And a moving party is entitled to summary judgment upon showing that there is no genuine dispute as to any material fact that might affect the outcome of the suit, and thus the matter does not need to be decided by a full trial. Judges may also grant a partial summary judgment by ruling on some factual issues while leaving others for trial. And in separate state-specific motions, the Texas and Connecticut plaintiffs argue that the state court records established that requisite undisputed facts to conclude that Jones inflicted willful and malicious injuries on the parties, and that the judgment debts arising out of such conduct are non-dischargeable as a matter of law. The plaintiffs further argued that Jones is barred from relitigating the finding that his conduct was willful and malicious under the principle of collateral estoppel because those facts were conclusively established before a different court. That's one of those rules that prevents someone that lost in court to go to a different jurisdiction and get a different trial and trying to undo that verdict. And not surprisingly, Jones opposed summary judgment, arguing that there has not been a formal determination of willful and malicious injury because the state court findings were default judgments, not full trials, and therefore collateral estoppel did not apply. And Jones further argued that the state court judgments against him were unfair and unconstitutional, and the bankruptcy court should not grant them full faith and credit by honoring their validity. And in two state-specific rulings against Jones, but not his company, U.S. Bankruptcy Judge Christopher Lopez of the Southern District of Texas granted partial summary judgment on most of the issues in favor of the Sandy Hook plaintiffs, while declaring that a few issues couldn't be summarily resolved and had to go to trial. Now, under long-standing Supreme Court precedent, collateral estoppel prevents issues of fact that were already determined by a valid and final judgment in a previous lawsuit from being relitigated in any subsequent lawsuit that involves the same parties. In bankruptcy court, plaintiffs can invoke collateral estoppel to establish that a debt is non-dischargeable. To determine if collateral estoppel applies, courts analyze the law of the state in which the judgments were entered. Under Texas law, collateral estoppel bars parties from relitigating issues when 1. The facts sought to be litigated in the second action were fully and fairly litigated in the first action, 2. Those facts were essential to the judgment in the first action. And the standard for collateral estoppel in Connecticut is basically the same with slightly different verbiage, like saying necessary to the judgment instead of essential. Now, Jones argued that collateral estoppel is inapplicable because 1. The precise issue of willful and malicious conduct was not fully and fairly litigated since the 3 default judgments were entered against him without trial, and 2. Jones was blocked from making certain defenses for the damages trials and thus denied the opportunity to fully participate in the action. But the bankruptcy court rejected those arguments, writing that, quote, default judgment orders like the ones entered against Jones have the effect of fully and fairly adjudicating a claim, and thus the issue of willful and malicious were properly litigated. Now, under bankruptcy law, debts arising from reckless or negligently inflicted injuries are subject to discharge, while debts arising from an intent to injure are generally non-dischargeable. For an injury to be the result of willful and malicious conduct, there has to be an intent to cause the injury, not just the act which leads to the injury. And to determine if there was an intent to cause injury, the court has to analyze from a reasonable person's perspective whether the defendant's actions were substantially certain to cause harm and are such that the court ought to infer that the debtor's subjective intent was to inflict a willful and malicious injury on the plaintiff. And to illustrate that distinction, Judge Lopez noted that a debtor's act of intentionally driving a car into a crowded bar and killing a creditor's relatives was found to be based on willful and malicious injury, while a debtor who illegally sold a rifle to an individual who years later shot people did not commit a willful and malicious injury. So in the latter case, the debtor's illegal intent to sell the rifle was not an act intended to cause harm to third parties, while purposefully driving a car into a bar clearly does involve a willful intent to injure. And turning to the Jones matter, Judge Lopez found that the petitions in the Texas and Connecticut cases contain multiple clear allegations about Jones's intent to cause those plaintiffs harm or substantial certainty that Jones's actions would cause harm. And under Texas and Connecticut law, all allegations in a petition are deemed admitted and the defendant's liability is established if a default judgment is entered against the defendant based on a discovery abuse. And you can see in the complaints in Texas and Connecticut that there are plenty of allegations that talk about Jones engaging in willful and intentional conduct. And that's a big problem for Jones because when you default in a case, it means that you are deemed to have admitted every single allegation in that complaint. So accordingly, Judge Lopez concluded the deemed admissions were sufficient to establish that Jones inflicted willful and malicious injury on the Sandy Hook plaintiffs, and the issue was fully and fairly litigated for the purposes of collateral estoppel. And then addressing the second prong of collateral estoppel, Judge Lopez concluded that the finding that Jones inflicted willful and malicious injury was necessary and essential to the Connecticut and Texas cases. Judge Lopez noted that the juries in the Connecticut and the Heslin-Lewis damages trial made specific factual findings that Jones acted with an objective certainty of harm and a subjective motive to cause harm. made, quote, findings about a deliberate and intentional act meant to cause injury, not just a deliberate act that leads to injury, and the jury, quote, awarded damages based on these findings. And accordingly, Judge Lopez granted summary judgment finding the following debts are non-dischargeable as a matter of law, including the $965 million in compensatory damages plus the $150 million in punitive damages from the Connecticut case, and the $4.31 million in compensatory and exemplary damages in the Heslin-Lewis defamation claim. However, Judge Lopez found that the record was not completely clear in some areas regarding what amounts of other damage awards were derived from reckless conduct, which is dischargeable in bankruptcy, as opposed to the intentional conduct, which is not. For example, the jury instructions for intentional infliction of emotional distress in the Heslin-Lewis matter said Jones acted either intentionally or recklessly with extreme and outrageous conduct. Since the jury did not differentiate between what damages flow from reckless conduct, a debt of which is dischargeable, versus willful and malicious conduct, debt of which is non-dischargeable, this issue couldn't be resolved on summary judgment. So accordingly, Judge Lopez denied summary judgment for an order to trial to resolve what damages stem from willful and malicious injury versus reckless conduct with respect to several of the intentional infliction of emotional distress claims, and the $321 million in attorney's fees awarded as common law punitive damages in the Connecticut case. Now, Jones argued that the judgments against him are unconstitutional and unfair, and thus the bankruptcy court should refuse to honor the judgments against him. He also asserted that the default judgments should not be afforded the preclusive effect of collateral estoppel, claiming that he was denied the opportunity to actively participate in litigation due to the default judgments and was wrongly prohibited from raising certain defenses. Now, the court declined to consider Jones's argument that the judgments were unconstitutional, stating in a footnote that the state court actions were fully and fairly litigated with Jones's participation, and the Supreme Court requires federal courts to give full faith and credit to state court judgments and jury awards. The court also rejected Jones's claim that the Connecticut court judgment was, quote, skewed with the intent to obtain a non-dischargeable judgment in anticipation of bankruptcy, noting, quote, there is no evidence of manipulation that even remotely warrants serious consideration of this argument based on the record before the court. Judge Lopez nonetheless informed Jones that he could make this argument, along with claims that he was denied the right to make certain defenses in the appropriate state appellate courts. And addressing Jones's claim that he was denied the opportunity to mount a defense, Judge Lopez highlighted that Jones had in fact participated in all three cases for multiple years, including the presenting of evidence for the Connecticut and the Heslin-Lewis damages trial, but chose not to comply with discovery orders, knowing full well that he risked default judgment. So Jones has no one to blame but himself for his own predicament. And explaining why the court will give full faith and credit to the Connecticut and Texas default judgments, Judge Lopez quoted the Illinois case of Herbstein versus Bretman, quote, where a litigant participated extensively, then failed to comply with an express court order issued multiple times at a risk of incurring default, the litigant should not now be able to sidestep the collateral estoppel doctrine and litigate an issue in this forum that was forestalled in another court due solely to the litigant's decisions. The litigant is not entitled to a second bite at the apple. The issue underlying the default judgment were actually litigated for the purposes of the collateral estoppel doctrine. So to be clear, this saga is far from over. I don't know that it will ever be over. Jones still has the right to appeal this ruling and the judgments in the other cases, but this is a monumental victory for the plaintiffs. And it's likely that without this ruling, that Jones could have been free to liquidate the debt-saddled free speech systems while being allowed to start another similar company free from the judgment debts. This in turn would have put the Sandy Hook families on the path of collecting only a fraction of the awarded damages. Now, the Sandy Hook families can continue to seek the maximum amount of recovery, and of course, Alex Jones could have avoided all this drama if he just paid what he owes.
Hey, next time pay your bills. But I don't want to.
But that's pretty weak tea, which is the opposite of the excellent coffee that I get from today's sponsor, Trade Coffee. Trade's great because not only do they have a huge selection of your favorite coffees, but they have a fine-tuned matching process that helps you discover fresh coffee based on your taste preferences. I have a very specific taste in coffee. I basically want something that tastes like hot chocolate and pairs well with milk. And Trade was able to find me the perfect bean. And let's be honest, you claim you want a rich dark roast, but you really want a coffee milkshake like I do. But either way, Trade has you covered. And now that fall is here, it's the perfect time to drink piping hot coffee, or if you're a crazy person like my friends, it's the perfect time to drink ice cold cold brew, which Trade also has a huge selection of. And with Trade, you can discover new coffees from the nation's top roasters, you can choose your coffee, rate it, and your coffee suggestions get even better every time. All conveniently delivered straight to you. It's really the best coffee website out there. And And if you already know what you like, they probably already have your favorite roaster in stock at a great price. You can even choose whole beans or your preferred grind. So if you'd like to try Trade Coffee, Legal Eagles will get their first bag free when they sign up. All you have to do is click on the link that's in the description or the one that's on screen right now. And not only will you get your first bag free, you'll also get free shipping. So get your first bag free by clicking on the link that's on screen right now. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.
Okay, well listen, if you don't tell me how you got this information, then you and I are gonna have some problems.
This is one of the absolute craziest things I have ever seen in court, and not in a good way. A Georgia judge has ordered a lawyer representing rapper Young Thug to spend the next 10 weekends in jail after finding him in contempt of court. Why? Because the judge had a secret meeting with the prosecutor and a witness and might have tried to coerce the witness. But we don't know for sure because the judge held a secret ex parte hearing without the defense present. That's not something you should do. When the defense lawyer, Brian Steele, inquired about the secret meeting, the judge got upset. Not about the meeting, but that someone snitched. As a result, Mr. Steele will go to jail with his client. Literally, he asked that he be able to be incarcerated with his client. That is so freaking metal. But how did we get here? Well, Young Thug, whose real name is Jeffrey Lamar Williams, is one of the biggest rappers to emerge from Atlanta's rap scene in the early 2010s. He's known for upending the traditional rules of rap using malleable vocal styles that include inflections and mumbles. His style blends elements of rap with trap, hip-hop, and R&B. Now, Young Thug first broke through with his mixtapes, 1017 Thug and Barter 6, and in 2019, his first studio album, So Much Fun, debuted at #1 on the Billboard 200. His most popular songs include Stoner, Danny Glover, Best Friend, and The London featuring J. Cole and Travis Scott. He has a record label called Young Stoner's Life. Now, in addition to being a boundary-pushing artist, Williams has faced some groundbreaking legal challenges as well. He and 5 other men are on trial in Atlanta in a sprawling criminal case. Prosecutors allege that Williams is one of the leaders of a street gang called Young Slime Life, or YSL. The indictment says that YSL is a criminal street gang that started in late 2012 in the Cleveland Avenue area of Atlanta, Georgia. YSL claims affiliation with the National Bloods gang. During opening statements, Fulton County Deputy District Attorney Adrian Love said, quote, "The members and associates of YSL moved like a pack with Jeffrey Williams as its head." Prosecutors claim Young Slime Life is involved in a range of criminal activities, including drug trafficking, murder, armed robbery, carjackings, and other violent crimes. The most serious allegation against Williams is that he rented a car that was used to murder rival gang member Donovan Thomas Jr. in 2015. Now, the Georgia Racketeer Influenced and Corrupt Organizations Act, or RICO, is typically used to target organized crime, and is currently being used to prosecute Donald Trump in Georgia. However, in practice, prosecutors use it to prosecute people participating in conspiracies that don't involve traditional mobsters. Williams and his co-defendants were indicted under Georgia's version of RICO. The state law was enacted in 1981, about a decade after the original federal RICO statute. And it's generally easier to convict someone under Georgia's RICO statute than in the federal statute. In part, it's because the law is expansive, but also has actual definitions. Georgia Code Section 1614-4 states, quote, "It shall be unlawful for any person employed by or associated with any enterprise to conduct or participate in, directly or indirectly, such enterprise through a pattern of racketeering activity." So a prosecutor must prove enterprise, pattern of activity, and racketeering activity under the Georgia RICO statute. And Williams is accused of conspiring to violate the Georgia RICO Act and participating in gang-related activities. And all that's interesting because the Williams trial started in January of 2023 and has been a wild ride with lots of controversial moments. Williams says that YSL is just a reference to his record label, and his lawyers argue that although there is a street gang known as Young Slime Life, it's not as violent as prosecutors allege, and that Williams isn't associated with it. And the prosecutors in the trial have cited several of his songs and lyrics as evidence, arguing that they demonstrate his involvement in criminal activity and his leadership role in the YSL gang. And the indictment claims that his songs are an overt act in furtherance of a criminal conspiracy. This is obviously controversial, and it's not unusual for artistic expression to include references to violence, but prosecutors are arguing that lyrics offer an insight into the gang activities and criminal intent, which is right out of a Key and Peele skit.
Stroke my chin real slow when I'm lying, and I was laughing super hard as Darnell was dying.
But that brings us to the present drama. Fulton County Superior Court Chief Judge Ural Glanville has ordered defense attorney Brian Steele to spend the next 10 weekends in jail after finding him in contempt of court. This decision came after Steele refused to disclose how he learned about a meeting between the judge, prosecutors, and a prosecution witness. Steele challenged the judge in open court, stating that he'd been informed of a meeting in the judge's chambers, that happened that morning. And according to Glanville's order, quote, during the proceedings in the above-styled case on the afternoon of June 10th, 2024, one of the two representatives for defendant Jeffrey Williams, Mr. Brian Steele, took to the podium and stated to the court that he had been informed of an ex-parte communication which took place in the court's chambers that morning. The only parties present for this ex-parte matter were the court's official court reporter, representatives from the state's witness, Mr. Kenneth Copeland, and counsel for Mr. Copeland. In addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. The court having told Mr. Steele multiple times that he needs to tell the court how he came into that information, and the court having explicitly warned Mr. Steele that he faces contempt of court should he not comply, the court finds Mr. Steele has repeatedly refused to follow the court's orders. Now, I guess that is technically an accurate description of what happened, but that only scratches the surface of the insanity. First of all, ex parte is a Latin phrase meaning on one side only, by or for one party. So an ex parte hearing is one where not all parties are present. And generally speaking, if anything happens in court, all the parties should be present. That seems obvious. And an ex parte communication occurs when a party to a case or someone involved with a party communicates directly with the judge about issues in the case without the other party's knowledge. Now, judges are generally not allowed to have these private conversations in matters pending before the court, or which can reasonably be expected to be filed in the court, except when all parties or counsel are present. And second of all, generally, the judge is not allowed to inquire into how an attorney learned of anything. Attorney-client and work product privilege exist, as well as the Fifth Amendment, and probably would have protected the attorney here, especially without a subpoena from the judge, if the judge even has subpoena power. But let's dig deeper. Now, we're going to look at the actual video of what happened in court, but first let's talk about the witness at issue here. Ken Copeland is a key witness in the trial. During opening statements, the prosecution said that Copeland was the triggerman in the murder of Donovan Thomas in 2015. Thomas was a rival gang leader who also worked in the music business. Prosecutors alleged that Young Thug wanted him dead because he was trying to lure rapper Rich Homie Quan to sign with Young Thug's label. And Copeland was not named in the indictment. He was originally charged with the Thomas murder, but the state dismissed the charges. However, he didn't enter into a plea agreement with the prosecutor, requiring him to cooperate in exchange for immunity. So when the prosecution called Copeland to testify, his lawyer, Jonathan Melnick, told the judge that his client would invoke his Fifth Amendment right not to incriminate himself. So prosecutors quickly offered Copeland immunity, and Judge Glanville dismissed the jury and informed Copeland that he would not be prosecuted for his testimony. So whatever he said would not incriminate him. The judge informed Copeland that he would go to jail if he refused to testify. The jury came back in, but Copeland then invoked his Fifth Amendment. The judge said, quote,
Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time.
Now, this is where things get even stranger. Prosecutor Adrian Love accused Melnick of conspiring with the prosecutors to stop Copeland from testifying. Melnick was not happy with that accusation. He told Love he would report her to the bar.
So what we are seeing, we believe, is tampering with witnesses. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with.
Now, defense attorneys for Williams and the other 5 defendants told the judge that they suspected the state knew Copeland intended to plead the Fifth, but they put him on the stand anyway, so he was forced to do it in front of the jury. The judge denied their motions for mistrial. On the next day of trial, Melnick had flown home because he had a non-refundable plane ticket, so attorney Caleb Bumpus was in court to represent Copeland. Although the trial was scheduled to begin at 9 a.m., it was delayed until 11:30. That's when Brian Steele approached the lectern and said he'd been notified that the judge held a secret meeting with the witness, Bumpus, and prosecutors in the judge's chambers.
And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on.
To which the judge replied,
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too.
Steele said he had heard a prosecutor tell Copeland he could be jailed until all the cases against all the defendants in the indictment were completed. Quote,
If that's true, what this is is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for.
Now, if you're accused of Georgia RICO, you'll probably want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you or a loved one is suffering from mesothelioma, lung cancer, or pleural disease, if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash, or just about anything else, we can represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is below. Now, state court rules prohibit ex-parte communications. Rule 4.1 says, quote, except as authorized by law or by rule, judges shall neither initiate nor consider ex-parte communications by interested parties or their attorneys concerning a pending proceeding. It further states that the only exception to this rules are as follows. Quote, where circumstances require ex-parte communications are authorized for scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex-parte communication, and the judge makes provision promptly to notify all other parties of the substance of the ex-parte communication and gives the parties an opportunity to respond. And in a case called Arnau versus Arnau, the Georgia Court of Appeals said that, quote, ex-parte communications are presumed to have been in error. In that case, the appellate court reversed the termination of visitation rights in a divorce case because the judge had an ex parte meeting with an expert psychologist after the trial had ended, but before his ruling. Quote, although Mr. Arnau had the opportunity to cross-examine Dr. Berlin during the trial, he was denied the opportunity to cross-examine the witness with respect to any opinions he offered during the post-trial meeting with the court or to respond to any new allegations or other evidence which may have been presented to the court. Ms. Arnau argued that the psychologist didn't offer any new evidence during that meeting and only summarized his prior testimony, but that was still unacceptable to the court. Quote, furthermore, even if such a showing had been supported by the record, the fact that ex parte communication is merely cumulative would not make the consideration of such evidence harmless error. Ex parte communications are presumed to have been in error. Now, Mr. Steele has already appealed, and in the emergency motion for supersedious bond, Steele said, quote, I demanded information regarding the meeting, including the names of everyone who was present, requested a transcript of the proceedings, and made a motion for mistrial on the grounds that an improper ex parte hearing was conducted with a sworn witness, Kenneth Copeland, which violated Mr. Williams's constitutional and statutory rights, including the right to due process and a fair trial. Now, going slightly backwards in time, in court, Judge Glanville denied Steele's motions and found him in contempt. The order of contempt cites Georgia Code section 15-1-3, which says, quote, every court has the power to compel obedience to its orders and to control the conduct of persons connected with a judicial proceeding. And the judge found that Steele had violated the section of Georgia Code that states that the court has the power to, quote, compel obedience to its judgments, orders, and process, and to the orders of a judge out of court in an action or proceeding therein. Now, I admit I'm at a loss as to what the judge possibly could have been doing here, but Jack Meltzer at SCOTUS Places came up with an interesting theory that might be applicable here. Under Georgia Code, a prosecutor can seek an order compelling a witness to testify in a criminal trial where they have been given immunity. That's pretty standard. But under Supreme Court of Georgia case law, arguably a criminal defendant doesn't have a right to be present when the prosecutor is seeking an order to compel testimony. But that particular case, King versus Georgia, is based on the idea that the defendant doesn't have a right to object to the compulsion of testimony, and therefore it doesn't matter whether the defendant is there or not. And that might be so, and maybe the judge was operating under that assumption, but that seems very different from the situation that we're dealing with here. And even if true, that doesn't mean that the state has an interest in keeping all of this secret after the fact. So what order did Steele disobey? Well, he refused to tell the judge how he had learned about the ex parte meeting. Now, judges have wide latitude to manage attorney conduct, but that doesn't necessarily mean that Steele had to disclose his sources. The Georgia Rules of Professional Conduct, which govern lawyers, says, quote, a lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate, or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent. And comment 5 explains, quote, the attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. So yeah, this means that whatever a lawyer learns during the course of representing a client is confidential and protected by privilege. So you would think that Steele cannot be compelled to give up his source, maybe even against a court order. And generally, to even be held in this kind of contempt, the conduct or statements need to interfere with the running of the trial itself. And Steele's appeal says that, quote, his statements and conduct did not interfere with or pose imminent threat to the preservation of order and decorum in the court or interfere with the orderly processes of the administration of justice, as evidenced by the fact that the court was able to continue the trial after its initial oral pronouncement holding Mr. Steele in contempt. Further, Mr. Steele's refusal to disclose the name of the individuals who informed him of the ex parte meeting, which he argued would constitute a direct violation of his duty of confidentiality imposed by Rule 1.6, in no way delayed or impacted the underlying trial. Moreover, any doubt must be resolved in favor of Mr. Steele's vigorous advocacy on behalf of his client, especially when he was raising serious concerns about the court's involvement in an ex parte contact with a sworn witness. Steele arguably had a right to know what Copeland said in chambers. And as defense attorney Andrew Fleischman pointed out, the things that Copeland said to the judge are admissible as evidence. Georgia Code section 24-6-622 says, quote, the state of a witness's feelings towards the parties and the witness's relationship to the parties may always be proved for the consideration of the jury. Now, the state insinuated that the defendants threatened Copeland not to testify against them. Megan Cuniff, who writes the blog Legal Affairs and Trials, reported Copeland's backstory. Quote, in a federal gun case from 2018 implies he took a machine gun in a pillowcase to a recreation center as an act of self-defense. As this court is aware, there were approximately 14 attempts on the lives of Mr. Copeland and or his family members leading up to his arrest in this case, according to the memo from October 17, 2018. It is these attempts and his discussion with law enforcement surrounding these attempts that led him to the decision to possess the firearm at issue. Okay, so what if Copeland was threatened by the defendants or YSL gang members? Well, that still wouldn't give the judge the right to have an ex parte meeting with the witness. The defense lawyers can't be excluded from those conversations. But Andrew Fleischman said, quote, in the most sympathetic reading possible, there was a threat to the witness and he wanted reassurance that he'd be safe, but defense counsel still gets to hear that. If a threat keeps a witness from testifying, the state can claim the defendant forfeited the right to cross. So there are other ways the court can handle threats to a witness. But the judge ordered Steele to serve 20 days in the Fulton County Jail by spending the next 10 weekends there.
All right, counsel, I've made a clarification to the order of contempt. Mr. Steele, I am going to hold you still hold you in summary criminal contempt pursuant to OCJ 15-1-3, subpart 3, for your failure to comply with my earlier order today. I'm going to order that you be taken into custody, incarcerated in the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends.
But in a move that will surely be recounted in lawyer cocktail parties for decades, Steele requested to serve his time in the Cobb County Jail, where Williams is being held to continue working on the rapper's defense.
I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time. That's up to you, and sir. I will, sir. If that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay.
Not surprisingly, Steele and his law firm immediately filed an appeal against the contempt order with the Georgia Court of Appeals. Steele argues that the judge was wrong to assert that the meeting was confidential because there was no court order ruling that any matter involving Copeland was confidential, and of course couldn't have been confidential because there was a third party there. And after Steele's arrest, 20 to 25 lawyers from the Georgia Association of Criminal Defense Lawyers appeared in court on Steele's behalf. Ashley Merchant, the defense attorney who discovered Fonnie Willis's affair with Nathan Wade, argued that Glanville should sua sponte, or on his own, transfer the contempt case to another judge because he's a witness to the contempt. And that's almost certainly right. The judge can't be impartial in his own case. But the judge impatiently tells her that Steele won't disclose his sources, and that's why he's in contempt of court.
If the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was.
In this clip, Merchant tells the judge that since it's a direct criminal contempt charge, Steele has due process rights.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list.
The judge said that he had already given Steele all the due process he's going to get on the spot.
Criminal contempt is different. It is on the spot.
Merchant argued that Glanville can't compel Steele to reveal confidential communications.
Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this This is a question the court's permitted to ask.
And this goes back to whether Judge Glanville had a right to ask Steele to disclose the confidential information without a court order. Merchant then explains that the issue is whether or not a hearing needs to be held right now. She contends that he's a witness to the proceeding, and it has to be referred to another judge because he's a witness. Judge Glanville asked Merchant to show the case law, and that's what she does.
You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older.
But Judge Glanville rejects those cases because he thinks they're too old. The most recent case is from 1994. But as Merchant pointed out, there aren't many cases involving lawyers being held in direct criminal contempt. Merchant cites In re Adams, where the Court of Appeals overturned a direct criminal contempt charge against a lawyer, where, quote, the trial court made the summary contempt finding without providing Adams with notice of such intent at the time the court scheduled the hearing thereon, and without providing him with an opportunity to be heard or to be represented by counsel before summarily finding Adams in criminal summary contempt of court. And that case supports Merchant's argument that in direct criminal contempt finding, the judge has to hold a hearing and allow the lawyer to present witnesses and cross-examine the other witnesses. But Judge Glanville is not done disciplining people in his court. In a Tuesday order, Glanville asked Fulton County prosecutors, witness Lil Woody, real name Kenneth Copeland, and the witness's attorney, Caleb Bumpus, to appear in a June 25th hearing and show cause for why they, quote, should not be held in contempt for disclosing information from the ex-parte conversation to members of the defense counsel. But wait, there's more. There is so much more. Defendant DeMonte Kendrick filed a motion for the judge to recuse and attached an affidavit from his lawyer, Douglas Weinstein. The affidavit alleges stunning acts by the judge and the Fulton County prosecutors. During the meeting, according to the affidavit, Copeland allegedly said, quote, he would sit in jail for 2 years rather than testify. And the prosecutors allegedly told Copeland that if he lied, they would not prosecute him. Quote, Chief Judge Glanville informed Copeland that Chief Judge Glanville could keep Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. One of the assistant district attorneys, either Hilton or Love, said, quote, there were over a dozen defendants left to try. After these threats by the judge and the prosecutors, Copeland relented and said he would testify. The affidavit says Judge Glanville printed out a copy of the perjury and making false statement statutes. Boy, that's pretty ironic given what happens next. And Copeland also allegedly said he would testify that he did murder Thomas. Quote, ADA Hilton and told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. So apparently the judge intends to hold a hearing to find the people who allegedly leaked all this information to the defendants. Now, luckily, the Supreme Court of Georgia stepped in and granted the supersedeas bond, so at least Steele won't be going to jail while we sort all of this craziness out. Even though Steele would have dined out on that for years. But it will be interesting to see what happens to the precipient witnesses of this ex-parte hearing, what happens to the lawyer, Steele, and inevitably whether there's going to be a mistrial, because there are going to be lots and lots of motions for mistrials. The bottom line is that Brian Steele made a motion in good faith about a meeting that should not have occurred without the defense present, and he's being thrown in jail for it. And if you're a lawyer and the judge sends you to jail, there's probably not much you can do. But if you're a lawyer or anyone else that deals with contracts, today's sponsor, Spellbook, will help you a ton and maybe keep you out of jail. Because Spellbook uses AI to review and suggest language for your contracts and legal documents right in Microsoft Word, helping you write and analyze entire contracts and documents holistically. You can draft, redline, and review contracts 10 times faster with AI. And the insights it provides me as I'm reviewing and writing documents is absolutely shocking. Now, I'll let you in on a little secret that only real lawyers know. No one starts a contract from scratch. We're always cribbing from other sources. But Spellbook is a huge time saver, whether you're a lawyer or just deal with contracts or legal documents in your job. Spellbook is trained on huge case databases, form libraries, and statutes, which means it can suggest accurate and relevant language for almost any legal document. Spellbook can draft entire documents from scratch, which are ideal for one-offs, and it can automatically build a searchable library of your most used legal language, so you can easily reuse your favorite clauses. You can use the chat prompt to give it almost any task you can think of, including generating automations for documents. And if you're analyzing a contract, which is what I usually do, it'll generate insightful comments and revisions. I plugged the latest contract I was negotiating into Spellbook, and it immediately identified a bunch of really important issues. It found contradictory clauses, missing terms, and non-defined terms. My favorite is when it pointed out that at one point the contract said 90 when it meant 90,000. Whoops. And Spellbook suggested additional clauses and ways the client could protect themselves from various situations. It found several, too many, potentially unenforceable terms, including a ridiculous penalty term, and one clause that, quote, might be considered overly broad and could potentially be challenged in court as it restricts the party's freedom of speech for a period extending beyond the term of the agreement. Yeah, that's not staying in the contract. It even suggested business-related revisions like the right of first refusal that would hamper future engagements. Now, obviously, it can't know everything about a contract or a case. You'll still need to adjust the clauses to your liking and still need to analyze everything. But it's a fantastic starting point. So whether I'm writing a contract or litigating one, I think my first step from here on out is going to be plugging that document into Spellbook. So click on the link below for a free 7-day trial and a 15% off discount to Spellbook. Spellbook has been a massive boon for any kind of legal writing, and now you can try it for free today. It saves me a huge amount of time and makes any legal document better. So click below for a free 7-day trial and an exclusive 15% off of a subscription. After that, click on this link over here for more LegalEagle, or I'll see you in court. In these trying times, when our nation is so divided, the only thing that can bring us all together is kicking one of the 2 presidential candidates off the ballot. Yes, that'll do it. Now our nation can heal.
God bless America.
Yes, a few months ago I told you that there was a possibility that Donald Trump would be ruled ineligible for the presidency because of Section 3 of the 14th Amendment. And now one state has actually booted him from the ballot. On December 19th, 3 years to the day after Donald Trump sent this infamous tweet announcing a mass protest, "Be there, it will be wild," the Colorado Supreme Court held that Trump is disqualified from holding the office of president because he participated in an insurrection. As a result, the court ruled that Trump cannot be listed on the Republican presidential primary ballot in Colorado. This decision opens up a big can of worms for the embattled U.S. Supreme Court. Will it overrule the Colorado Supreme Court? How will it structure its decision? What precedent might this set for other states? And of course, what's also going on with Michigan and Maine as Trump gets kicked off another ballot? Today, we're going to talk about the ramifications of this decision. But first, what in the world just happened in Colorado? Well, in October, a group of Colorado electors eligible to vote in the Republican presidential primary, including both registered Republican and unaffiliated voters, filed a petition in the district court for the county of Denver, asking the court to rule that the former President Trump may not appear on the Colorado Republican presidential primary ballot. The plaintiffs asserted that he, quote, was ineligible under Section 3 because he engaged in an insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. The district court conducted a 5-day trial and then found by clear and convincing evidence that Trump engaged in an insurrection as those terms are used in Section 3 of the 14th Amendment. However, the district court concluded Section 3 does not apply to the president because the presidency is not in office and therefore the president is not an officer of the United States. The plaintiffs appealed and the Colorado Supreme Court partially overturned the district court decision, finding that Trump committed insurrection and that he was an officer of the United States. The first issue was whether the state had jurisdiction to decide whether a presidential candidate had participated in an insurrection and was therefore disqualified from the ballot. Now, you might legitimately wonder why in the world we would want 50 different standards for how an election is administered. Well, take that up with the Founding Fathers. Since the Constitution delegates to the states the authority to prescribe the times, places, and manner of holding congressional elections, the states retain the power to regulate their own elections. Now, I'm not going to do a deep dive into the applicable Colorado statutes because we have a lot of material related to the federal Constitution, and the Supreme Court's not going to care that much about the actual Colorado election law issues here. So let's move on to the text of Section 3 of the 14th Amendment to the federal Constitution, which reads, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in an insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each house remove such disability." Section 3 was added to the Constitution after the Civil War, when Northern Republicans were outraged at the prospect of Southerners who seceded from the Union returning to hold positions of power in the same government that they tried to destroy. This was their way of saying that if you ever participated in an insurrection in this country, you aren't eligible to serve as an officer of the United States. But they didn't define all the terms that they used in Section 3, so the court had to do it for them. So the Colorado courts first had to determine whether Trump had participated in an insurrection. When the 14th Amendment was ratified, there was an assumption that everyone knew what an insurrection looked like because there had just been a civil war. It seems that Congress would block anyone that it felt had participated in the Confederacy. But in the absence of a civil war, what are we to do? Well, the Colorado Supreme Court started with the dictionary definition of the word insurrection. Merriam-Webster says it's an act or instance of revolting against civil or political authority or against an established government, or an act or instance of rising up physically. And the court agreed that insurrection for purposes of Section 3 has to to include a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transition of power in this country. And the Colorado courts concluded that whatever definition you're using, it would apply in this scenario. Right after January 6, Republicans quickly recognized that what had happened met the general definition of insurrection, just like their Reconstruction-era ancestors. Here's Majority Leader Mitch McConnell on January 7, 2021, using the same definition as the Colorado court.
It was a violent insurrection for the purpose of trying to prevent the peaceful transfer of power after a legitimately certified election from one administration to the next.
Trump's lawyers declined to offer a definition of insurrection, instead arguing that an insurrection is more than a riot, but less than a rebellion. The court agreed that, quote, an insurrection falls along a spectrum of related conduct, but no authority supports the position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve a particular length of time or geographic location. The bottom line is that there has to be a group of people who use violence in a public way, and violence also has to be directed towards achieving some kind of public purpose. A private act or even a conspiracy to commit a crime doesn't rise to the level of insurrection, and the required force or threat of force doesn't require bloodshed, nor does it require those involved to be highly organized at the insurrection's inception. And you can see how this definition might include Trump's actions before and during January 6th.
Mike Pence is going to have to come through for us, and if he doesn't, that will be a sad day for our country.
Pence cave, we're going to drag through the streets. You politicians are going to get drugged through the streets.
And during the events of January 6th, the court said, quote, it is undisputed that a large group of people forcibly entered the Capitol and that this action was so formidable that law enforcement officials on site could not control it. The court slammed Team Trump for arguing that no one was armed on January 6th, since the mob was armed with a wide array of weapons.
The Oath Keepers stored a cache of weapons for a QRF, or quick reaction force, that would respond to the Capitol armed if President Trump were to, quote, declare an insurrection and to call us up as the militia.
Many of the rioters also stole objects from the building and even from the police, including metal rods, shields, and batons. And then the court considered whether Trump really engaged in an insurrection for purposes of Section 3, since Trump wasn't with the mob when they entered the Capitol building. There wasn't really much precedent, so the court looked at treason cases. In 1807, Chief Justice Marshall explained that, quote, all those who perform any part, however minute or however remote, from the scene of action and who actually lead in the general conspiracy are to be considered traitors. The Colorado court held that engaged in requires an overt act and voluntary act done with the intent of aiding or furthering the common unlawful purpose, and concluded that Trump engaged in an insurrection. Here the court notes that Trump laid the groundwork as early as August of 2020 when he said the election would be rigged against him. In September, he refused to commit to a peaceful transfer of power. The court emphasized that Trump and his supporters were united in the purpose of stopping Congress from certifying the election. Quote, the mob was coordinated and demonstrated a unity of purpose. They marched through the Capitol building, chanting in a manner that made clear that they were seeking to inflict violence against members of Congress and Vice President Pence. And upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, and reached the House and Senate chambers within minutes of entering the building. The mob achieved its objective, at least temporarily. Quote, this breach caused both the House and Senate to adjourn, halting the electoral certification process. In addition, much of the mob's ire, which included threats of physical violence, was directed at Vice President Pence, who, in his role as president of the Senate, was constitutionally tasked with carrying out the electoral count. In other words, the mob wasn't on a tourist trip taking selfies, as some Republicans have recently insisted. They wanted to stop the peaceful transfer of power. Now, if you ever get kicked off a ballot, then you'll need a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've been in a car crash, suffered from sexual harassment, or are dealing with Social Security or workers' comp issues, we can represent you or help find you the right attorney who can. It's so important to talk to an attorney right away so you don't lose your chance for a full recovery and maximize your options. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is below. The Colorado Supreme Court agreed with the district court that Trump was no innocent bystander in these events. He recruited, quote, Proud Boys, the Oath Keepers, and the 3 Percenters, QAnon conspiracy theorists, and white nationalists to travel to Washington, D.C. on January 6th. The court concluded that Trump was aware of and sanctioned violence. The court suggested that the mob never would have assembled if Trump had not invited them. Quote, at this point, the record established that President Trump's plan was that when Congress met to certify the election results on January 6th, Vice President Pence could reject the true electors who voted for President Biden and certify a slate of fake electors supporting President Trump, or he could return the slates to the states for further proceedings. Now, the Colorado Supreme Court overturned the lower court's decision that the president is not an officer of the United States. Now, the district court concluded that the presidency is not an office, civil or military, under the United States for two reasons. First, the court noted that the presidency is not specifically mentioned in Section 3, though senators, representatives, and presidential electors are. The court found it unlikely that the presidency would be included in a catch-all of any office, civil or military. Second, the court found it compelling that an earlier draft of the section specifically included the presidency, suggesting that the drafters intended to omit the presidency in the version that it passed. But the state Supreme Court concluded that the specifics of that change don't prove that there wasn't an intent to exclude the presidency from the covered offices. This part of the majority opinion focuses on the spirit of the law rather than the letter, because it concludes that it would have been logically absurd for Section 3's drafter to exclude the president from the list of people who shouldn't be allowed to hold elective office if they participated in an insurrection. Quote, the drafters of Section 3 were motivated by a sense of betrayal, that is, by the existence of a broken oath, not by the type of officer who broke it. All of us understand the meaning of the third section, Senator John Sherman stated. It includes those men who have once taken an oath of office to support the Constitution of the United States and have violated that oath in spirit by taking up arms against the government of the United States are to be deprived for a time at least of holding office. The majority opinion also makes a textual argument by finding that, quote, the Constitution refers to the presidency as an officer 25 times. The court also notes that the Constitution refers to the presidency as an office under the United States in several contexts that seem to support the conclusion that the presidency is such an office. And as another example, they cite the impeachment clause, which reads that Congress can impose, as a consequence of impeachment, a disqualification to hold and enjoy any office of honor, trust, or profit under the United States. If the presidency is not an office under the United States, then anyone impeached, including the president, could nonetheless go on to serve as president. This reading is nonsensical, as recent impeachments demonstrate. The court's point is that it would have been weird if the impeachment proceedings against Trump and Bill Clinton would have resulted in their removal from office and disqualification to hold any future office, except for the presidency. The Colorado court concluded that, quote, President Trump undertook all of these actions to aid and further a common unlawful purpose that he himself conceived and set in motion, prevent Congress from certifying the 2020 presidential election, and stop the peaceful transfer of power. The court held that Trump is barred from the primary ballot, although that decision is stayed through the Supreme Court's review. Now, all 7 of the Colorado justices were Democrats, and the result was 4 votes to 3. The 3 dissenting justices also raised substantive issues that may get the attention of the Supreme Court. Some of the dissenting justices said that the court didn't give Trump enough due process. Now, what constitutes sufficient due process to disqualify someone from the ballot? That's an open question. Should the person have the same safeguards they would in a criminal trial? Or should the process be more like a civil case? We don't really know. Here, in this particular case, there was a 5-day trial in the district court where both sides presented testimony, and the court came to a conclusion. Trump was represented and filed briefs outlining his position. The parties called witnesses, and many third parties filed supplemental amicus briefs to help the court decide. But on the other hand, the hearing lacked discovery. Neither side could subpoena documents or compel witnesses, and it was decided by a judge rather than a jury. The dissenting justices also said that maybe there should be an independent procedure, something akin to a criminal trial, before a court rules that a person can't appear on the ballot. The disqualification clause is frustratingly silent on whether there must be an independent proceeding, so the question is whether Section 3 is really self-executing. Now, a law is self-executing if it is immediately effective without further action, legislation, or legal steps. The Supreme Court has never decided this issue, but Chief Justice Solomon Chase opined on it while he was a circuit justice for Virginia. In 1854, Chase was going to preside over the treason trial of Jefferson Davis. Now, that trial never happened because President Andrew Johnson gave him a pardon. But Chase allegedly told Davis's lawyer that he viewed Section 3 as a criminal punishment and that if Davis was disqualified, he would not face a criminal trial. Then in 1869, Chase decided a case called In re Griffin. Caesar Griffin had been sentenced to a 2-year prison sentence for assault by a state judge who happened to be a former Confederate officer. Griffin argued that the judge was disqualified under Section 3 and that it was self-executing. Justice Chase disagreed. Here he held that the legislation by Congress providing for removal was necessary to give effect to the prohibition of Section 3. And without such legislation, the judge was entitled to continue in his position. Now, remember when I said earlier about 50 states and 50 different rules? Well, the Michigan Supreme Court has ruled that Trump's candidacy was a political question, and Michigan law didn't give the Secretary of State the right to keep him off the ballot. But in Maine, the legislature delegated authority to determine candidate qualifications to the Secretary of State. So Maine voters filed 3 administrative challenges to Trump's presence incumbents on the primary ballot, and the Maine Secretary of State, Shenna Bellows, held a hearing where Trump's lawyers and the challengers argued the merits of disqualification. And Bellows has now ruled that Trump is ineligible to be listed on Maine's primary ballot. Now, the decision was made by the state official rather than a court, but the rationale is pretty similar to Colorado. Trump tried to prevent the peaceful transfer of power on January 6th. The riot was an insurrection, and Section 3 bars Trump from office. Bellows relied on the testimony of a historian who said that some, quote, members of Congress believed the presidency was in office when the amendment was being debated, as did contemporaries outside of Congress, including those who sought to keep Jefferson Davis from the presidency. Therefore, Bellows found it, quote, implausible that the drafters of Section 3 chose to exempt the highest office in our government from an amendment designed to keep Confederates from positions of power. Bellows said, quote, I am mindful that no Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. I am also mindful, however, that no presidential candidate has ever before engaged in insurrection. The Maine decision is pitched directly at the Supreme Court's conservative wing, which has ruled that the court must prioritize the normal and ordinary usage of words rather than secret or technical meanings that would not have been known to the ordinary citizens in the founding generation. And as Bellows notes, that language comes from the District of Columbia versus Heller, where the court held that the Second Amendment guarantees an individual right to possess firearms independent of service in state militia. Now, it's almost certain that Trump will appeal that decision. So the question is, will the Supreme Court take these cases on? Well, that's pretty likely. While the Supreme Court has just recently turned down Jack Smith's request for hearing the immunity cases directly without waiting for the Court of Appeals, it's hard to picture that the Supreme Court would allow states' courts to have the final word on the meaning of Section 3 of the 14th Amendment. And most commentators are assuming that the court will overturn the rulings and let Trump run for president in one way or another. But the way they do it, it's going to be, of course, very fascinating. But you can also be certain that the court will claim that politics had nothing to do with their reasoning. And you can already see how this case is scrambling the normal political and legal valences that would exist in a case like this, with many Democrats using principles of originalism or textualism to look at the text and original intent of the 14th Amendment to disqualify Trump from the ballot, and also many Republicans explicitly bringing politics into things, saying that we should ignore the textual and original meaning of the 14th Amendment and look to the political ramifications. And constitutional law professor Steve Vladeck has summarized the political and legal ironies that this case brings up on the excellent It's Complicated podcast.
I realize this is a weird argument for a constitutional law professor to make, but these are weird times. I mean, I tweeted this Tuesday night and knew I was going to get in trouble for it and did. But I think you can believe at the same time that President Trump engaged in insurrection and that he ought to be disqualified from ever holding office again, and also believe, given the Republican Party's casual relationship with truth and facts and evidence and widespread endorsement of January 6th related and election related conspiracy theories, that it's actually better for our politics if Trump loses having been on the ballot in all 50 states than if he loses having been kept off the ballot in a handful of states by this, maybe correct, Asha, but novel application of a constitutional provision that very few people had heard about before 2021. And so, I think what this really is, and I mean, you know this as well as anyone, is, the dirty little secret is that law is not an absolute, right? Law is part of a mush that politics is also part of. And I think that the Supreme Court probably was hoping against hope that they didn't get dragged into this mess. And that maybe the Colorado Supreme Court, like the Minnesota Supreme Court, found a way to not keep Trump off the ballot. And to me, the real headline of what happened on Tuesday is now I think the Supreme Court has to step in against, not wanting to, and in a way in which there's almost no, obvious win, right, for the Supreme Court.
Yeah, it's weird times in the world, and politicians are getting doxxed and swatted left and right, all for their political beliefs, which is terrible. Never swat someone. It's a felony. You'll go to jail. But it's possible because so much of your personal data, like your personal address, is online, which is why I use today's sponsor, Incogni. Incogni removes your personal data from online data brokers. They reach out and make sure it's taken down. If these data brokers object, which I've seen, Incogni will take care of that too. It's amazing. Now, I don't know if you've ever Googled yourself, but there are major people search sites out there that probably have your personal contact info too. It might be because of a data hack, but sometimes our friends and family even provide that info voluntarily by clicking on one of those boxes when they sign up for websites or apps. These sites provide in-depth records, including information such as home addresses, contact details, license plate numbers, family members, financial information, and even religious and political beliefs. These sites can expose you to a wide range of dangers, from scams to identity theft to online harassment and stalking. Now, it was very important for me that I not appear on those sites, and Incogni took that information down. And not only does Incogni help with your online personal info being taken down, but it can also stop marketing efforts. I've seen a huge reduction in the amount of spam emails that I get, spam calls, and spam texts. And it's no surprise why I was getting all of this spam. According to the 2022 annual data breach report by the Identity Theft Resource Center, the number of victims has gone up nearly 41% from 2021. I was constantly getting notified that my information was part of a data breach. So when that happens, Incogni fights for you to have your personal data taken down from data brokers. Believe me, so many people have it, tackling this yourself would be nearly impossible. But that's where Incogni comes in. Incogni fights on your behalf to remove your personal data from data brokers and deals with any objections from their side. All you have to do is create an account and give them approval to work on your behalf. Incogni conducts repeated ongoing removals because even if the brokers remove your data once, they can collect it again and then use it again. Incogni makes sure that your personal information stays off the market for good. And it was fascinating for me to look at my own dashboard and realize that I'm on hundreds of data brokers lists. Here's part of my personal Incogni dashboard. It shows that these 3 sites had data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers had data including my contacts, financial data, and health data. It was terrifying to see exactly how many brokers had my data, but it was really fun to watch Incogni get them to delete that info one by one. So if online privacy is important to you, give Incogni a try. You can click on the link below to get 60% off Incogni when you use the code LegalEagle. So again, to get an exclusive 60% off discount, just click on the link that's on screen or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court. Elizabeth Holmes aspired to be Steve Jobs, but it turns out that she's more like Bernie Madoff. In 2003, a 19-year-old college dropout named Elizabeth Holmes founded a company called Theranos that promised to revolutionize blood testing. She claimed to have invented a machine that could run more than 200 tests on just a few drops of blood taken from a finger prick. She wanted to sell diagnostic tests directly to consumers. Holmes was very persuasive. She gave a TED Talk where she promoted Theranos by calling it the most disruptive technology in the history of medicine.
Yet in the United States today, healthcare is the leading cause of bankruptcy, and the lack of it, the leading cause of the suffering associated with finding out too late in the disease progression process that someone you love is really, really sick.
Silicon Valley investors treated her like a rock star. Walgreens quickly became a corporate partner. Major investors included Rupert Murdoch, the Walton family, and the family of former Education Secretary Betsy DeVos. Holmes's big promises attracted some of the biggest names in American government and foreign policy. Bill Clinton was charmed by her, and Joe Biden praised her efforts. Secretaries of State Henry Kissinger and George Shultz joined the board of directors. Former Secretaries of Defense James Mattis and William Perry joined too. The company raised nearly $1 billion in funding. With the prospect of eliminating many lab tests and their associated costs, there seemed to be nothing stopping Theranos from becoming a mega player in the biotech industry. Its highest valuation was an eye-popping $9 billion. But Walgreens, Murdoch, the US foreign policy establishment, and the other investors ignored a very important principle in investing and life. If something seems too good to be true, it probably is too good to be true. As it turns out, there's no way to run hundreds of sophisticated diagnostic tests on a few drops of blood. Despite all the evidence that Holmes knew her testing machine would never work, a federal jury convicted her on just 4 of the 11 charges against her, 3 for wire fraud against investors and 1 for conspiracy to commit wire fraud against investors. One juror said it was tough to convict her because, quote, she was so likable, she had such a positive dream. And it's a dream that they think she honestly still believes in. But as you can see, there's probably a reason why Jennifer Lawrence, Katie Holmes, and Amanda Seyfried are all practicing their most charming and cold-blooded stares. So today we're going to talk about the Elizabeth Holmes trial. Why did the jury find her guilty? Why did they acquit her on the other charges? And how much did Holmes help herself by testifying in her own defense? So let's start with the problems with Theranos, which have been well chronicled at this point. Blood analysis is one of the most important areas of medicine. The 2 main players in the field, Quest Diagnostics and Laboratory Corporation of America, generate over $75 billion a year in revenue. Theranos promised to upend this regime by eliminating blood draws, vials, large needles, and lengthy waiting periods? What if you could just go to Walgreens, buy a testing kit, and screen yourself for high cholesterol, kidney disease, or even cancer? Wouldn't that be great? You'd save time, money, get diagnosed faster, and lives would be saved. And that was the heart of the Theranos project. But there was just one problem with this vision. Most blood tests could not be done with just a few drops of blood. There aren't enough molecules for detection. One of Holmes' professors had rejected her early ideas for biotech companies on the basis that the science and technology could not exist. The professor, Phyllis Gardner, later said that she found the conversations concerning because Holmes refused to accept that some ideas were not possible. She said, quote, "The hubris of that just drove me insane." But Holmes dropped out in 2004 and went on her own way, aggressively selling her ideas to investors. Her company named Theranos is a combination of therapy and diagnostics. And while Holmes never submitted any of her inventions for any kind of peer review, that didn't matter to another Stanford professor, Channing Robertson. He said that the minute he heard her idea about a diagnostic test from a pinprick, he felt he was, quote, looking into the eyes of Steve Jobs or Bill Gates. Steve Jobs was, of course, the person that many company founders wanted to emulate. Jobs created his own persona, dressing only in black and promoting himself as an eccentric genius. Holmes took note of this and created her own mythos that was trying to piggyback on Jobs. She wore a black turtleneck and black suit every day. She had a intense stare that became famous. And we might laugh about this now, but according to Tyler Schultz, a Theranos employee, investors like his grandfather, George Schultz, were mesmerized by this act. But then came the whistleblowers. In 2014, Tyler Schultz emailed Holmes to complain that Theranos had doctored research and ignored failed quality control checks. Several other employees had also raised concerns about the company's science. George Schultz was 95 at the time, and Holmes called him immediately to warn him that she would get revenge on his grandson if he took his complaints any further. Tyler, though, anonymously contacted New York State's Public Health Lab and filed a complaint alleging that Theranos had manipulated a process known as proficiency testing, relied on by federal and state regulators to monitor the accuracy of lab tests. Theranos' lawyer, David Boies, who later joined the board of directors, surprised Tyler at his grandfather's house, informing him that the company was suing him for violating the terms of his NDA. And while Tyler was the first person to raise concerns about Theranos to outside regulators, he wouldn't be the last. In 2015, the Wall Street Journal published a series of articles exposing the Theranos testing machines as frauds. By then, Holmes had been appointed to the Harvard Medical Board alongside her old professor, Phyllis Gardner. Gardner spoke with the Wall Street Journal about her belief that Holmes was a fraud. And sure enough, regulators soon discovered that Holmes' Edison machines frequently failed quality control checks. That means they produced unreliable test results. Theranos eventually told regulators that it voided all test results from Edison machines for 2014 and 2015, as well as some other tests it ran on conventional machines. The Edison machine turned out to be a lemon. Theranos claimed that its test for one sexually transmitted infectious disease was sensitive enough to detect the disease 95% of the time. But when these results were submitted for validation, it showed sensitivities of between 65% and 80%. At the time, Walgreens was partnering with Theranos to provide in-store testing centers at 40 Walgreens locations. But when Walgreens realized the scope of the problem, they sued Theranos for $140 million. Walgreens eventually claimed that Theranos voided 11.3% of all blood test reports that the company provided to customers of Walgreens stores. But instead of acknowledging the problems with the Edison machine, Theranos fabricated the results while continuing to market the company to investors as world-changing technology. During the trial of Elizabeth Holmes, prosecutors showed a presentation that she had made to the board of directors, saying that 10 of the 15 largest pharmaceutical companies in the world had validated the Theranos results. This was a lie. The U.S. Centers for Medicare and Medicaid Services investigated Theranos and banned Holmes from operating a medical lab for 2 years. The U.S. Securities and Exchange Commission, the SEC, charged Holmes and former Theranos president Sunny Balwani with fraud and barred Holmes from serving as a director or officer of a public company for a decade. So that brings us to the criminal case itself. Holmes was indicted on 11 felony charges in 2018. The charges included wire fraud against investors, wire fraud against patients, and conspiracy. And federal prosecutors painted Holmes as a charlatan who knew her technology didn't work. They said she was obsessed with fame and fortune, and prosecutors presented evidence that when Theranos realized its test results were not accurate, the company substituted tests from regular blood draws, making it look as if the tests were from blood droplet tests rather than traditional blood draws in conventional machines. But the strongest evidence showed that Holmes exaggerated the company's involvement with potential partners. Prosecutors demonstrated that Holmes lied about having deals with drug companies like Pfizer and the US military. Holmes even added the logos of Pfizer and Schering-Plough to lab reports that she used in her presentation to investors and Walgreens executives. But these companies hadn't actually validated any of Theranos' systems. But the defense put on a case as well. Holmes testified for 7 days, presenting herself as a visionary woman in a male-dominated field. Holmes told the jury that she still believed that Theranos was on the verge of proving its technology worked. She blamed her ex-partner, Sunny Balwani, for misleading regulators about the tests. Holmes told the jury that the two had secretly lived together and that Balwani abused her throughout the relationship. And Balwani himself will go on trial later this year. And Holmes attempted to raise a good faith defense to the wire fraud charges. Although good faith is a defense to wire fraud, an honest belief in the ultimate success of the enterprise is not in itself a defense. And the judge instructed the jury that if they believed that she acted in good faith in her representations, then she could not also have acted with an intent to defraud. So let's dig into the elements of wire fraud and the conspiracy charges that she faced. Holmes was eventually convicted of 3 counts of wire fraud and conspiracy to commit wire fraud. 18 U.S.C. 1343 is the wire fraud statute. It states, whoever having devised or intending to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises, transmits or causes to be transmitted by means of wire, radio, or television communication in interstate or foreign commerce, any writings, signs, signals, yada yada, shall be fined under this title or imprisoned not more than 20 years or both. So the prosecution had to prove 4 elements. First, that she knowingly participated in some sort of scheme to defraud and obtain money or property from other people. Expressions of opinions, aspirations, or goals, or general subjective claims can't be used as a basis to find that someone made a false or fraudulent representation. This is an important point, and one we'll come back to when we talk about the jury's conclusion that she didn't defraud consumers. Probably because some jurors said that she believed that she had positive goals. But the second prong is that the statements made as part of the scheme have to be material. Statements tend to be material if they have a natural tendency to influence or were capable of influencing a person to part with their money. The third prong is that the government needed to show that Holmes acted with the intent to defraud, that is, that she had the intent to deceive and cheat someone out of their money or property. And then the fourth prong is that Holmes used interstate wire communication to carry out an essential part of this scheme. And the jury found that Holmes's misrepresentations influenced investors to send money to Theranos, and that her presentations actively intended to defraud investors by making them believe that Theranos had big government contracts and private partnerships that would produce a high rate of return on their investment. And the jury also found that Holmes had agreed with other people to perpetrate this scheme on others. That's why she was convicted of a conspiracy to commit wire fraud as well. The prosecution had lots of evidence that Holmes concocted test results to convince investors that the science behind her test was sound. In a 2014 Forbes article, Holmes said that Theranos, quote, does not buy any analyzers from third parties, and that was absolutely a lie. Theranos presented results conducted on these third-party analyzers during their presentations to investors, and it's highly likely that the jury thought that these lies were material and that they convinced investors to part with their money. And the 3 counts represented a total of about $142 million in fraud. But the jury deadlocked on 3 additional wire fraud counts related to investments from 3 Theranos investors, Alan Eisenman, Chris Lucas of Black Diamond Ventures, and Brian Tolbert of the Hall Group. Prosecutors now have to decide whether they are going to retry her on those 3 counts because the jury hung, so they couldn't come to a decision on those particular counts. But Holmes and Balwani were also accused of conspiring to commit wire fraud in violation of 18 U.S.C. 1349. The DOJ charged Balwani and Holmes with making materially false and misleading statements to investors. The government alleged that the duo, quote, made materially false and misleading statements to investors and failed to disclose material facts. This included telling investors that the company's proprietary analyzer was accurate when in truth it had serious accuracy problems, performed a limited number of tests, was slower than some competing devices, and could not compete with larger conventional machines in high throughput or the simultaneous testing of blood from many patients. Holmes and Balwani promised investors a return on their investment in the hundreds of millions of dollars while knowing that the company would only gross a few $100,000 in 2014 and 2015. Prosecutors proved that Balwani and Holmes faked test results during live presentations for investors, and the DOJ also said that Holmes told investors that the Walgreens partnership would be expanding, when in reality, Walgreens was already moving to end the partnership. Balwani and Holmes told investors that the Theranos technology had already been deployed by the U.S. military on the battlefield in Afghanistan, which was untrue. General Mattis testified that they were not being used by the military. When the jurors spoke out after the verdict, 2 of them said that the jury ranked witnesses according to their believability and that they rated Mattis as the witness with the highest credibility. Not surprising. Mattis said that he wanted the military to do a test program of Theranos analyzers, but the test never happened. Balwani and Holmes told investors that they didn't need FDA approval for the machines and tests when they already knew that they needed clearance from the FDA. And the two also allegedly lied to the media and then used the articles and news segments containing their lies to promote Theranos to investors. And to find Holmes guilty of the conspiracy charges, the jury had to believe that she hatched a plan to commit wire fraud in partnership with Balwani or others. If the jurors thought that she just went along with Balwani because of their partnership, that probably wouldn't have risen to the level of conspiracy. But what about the other charges of fraud for crimes perpetrated against patients? The jury actually acquitted Holmes of wire fraud and conspiracy to defraud patients. So let's talk about why that likely happened. During the 4-month trial, the prosecution devoted very little time to proving this part of the case. The patients who purchased Theranos tests only testified for about 1 hour in total. The government accused Holmes and Theranos of making material misrepresentations about his Edison machine in advertisements. The ads mostly targeted physicians. The prosecution argued that these ads induced hundreds of patients to pay Theranos or Walgreens for blood tests and test results, which obviously wouldn't have worked. The government said Balwani and Holmes told doctors and patients that Theranos could provide accurate, fast, reliable, and cheap blood tests and test results, but they already knew that Theranos technology was in fact not capable of consistently producing accurate and reliable results. This was the alleged wire fraud because Theranos used interstate electronic wires to purchase advertisements intending to induce individuals to buy the tests at Walgreens and stores in California and Arizona. And the prosecution had evidence that Theranos placed advertisements in Walgreens and on TV with their total marketing effort slightly over $1 million. But at the same time, the prosecutors didn't have the same kinds of direct communications between Holmes and individual patients as they did between Holmes and investors. And theoretically, patients only used Theranos tests because they were referred by their physicians. So it's possible the jury might have believed that there were too many intermediaries between Holmes and the individual patients, and doctors to conclude that Holmes actually influenced the patients themselves. And the defense argued that the prosecution needed to show that Holmes really intended to defraud these patients. Arguably, her company gave patients inaccurate test results, but inaccurate test results alone don't necessarily meet the criteria for an intent to defraud. The prosecutors needed to prove beyond a reasonable doubt that Holmes knowingly participated in, devised, or intended to devise a plan to defraud these patients. And as we talked about earlier, generally opinions, aspirations, goals, or subjective beliefs can't be used as a basis to find that someone made a false or fraudulent representation. And the jurors who spoke out after the verdict said that they believed Holmes when she said she never intended to defraud patients. And juror number 6, Wayne Katz, an Emmy-winning TV writer for a 1990s show called Tiny Toons Adventures, was inspired by Holmes's testimony. Quote, "We respected Elizabeth's belief in her technology, in her dream. We thought she still believes in it, and we still believe she believes in it." He's saying that she had a subjective belief even to this day that she was helping her patients, not hurting them. Katz said that the jury quickly decided to acquit Holmes on all 4 counts of fraud against patients. The jury thought Holmes was one step removed from the patients so that they were not directly defrauded. Of course, this was also somewhat contradictory since Katz also opined that everything ran through Holmes. But this is just what you often get from jurors who are grappling with difficult questions of law. Mike Q, juror number 11, said that although the panel thought Holmes's credibility was low, they also believed that she was genuine. But what happens next? Each of the 4 counts that Holmes was convicted of carries a maximum sentence of 20 years in prison. So theoretically, she could get 80 years in prison, but this will be reduced and modified by the federal sentencing guidelines. Several former prosecutors think she'll probably get less than 20 years in prison, especially as a first-time offender. And the high-profile nature of the case and the scope of the fraud probably suggests that she won't exactly get a slap on the wrist, though. That's because the federal sentencing guidelines require the judge to consider the magnitude of the lies and how much money the investors lost, and the fact that she was CEO. In these kinds of white-collar crimes, the more money that is pilfered, the more prison you can get, and $140 million is quite a lot. Though Holmes may be able to sway the judge for less prison time by pointing to her relative youth, her capacity for change, and the allegations of abuse at the hands of Balwani. And there will almost certainly be a very hefty fine. The government can retry her on the other wire fraud charges, but that seems unlikely. The government has already spent significant resources and time on the case, and they got a conviction on 4 counts carrying a serious prison sentence. So that may be enough, particularly in light of the upcoming Balwani trial, which is also probably going to be an expensive prosecution. So it turns out that Theranos was a fraud and a terrible investment, but you can avoid terrible investments and start investing for your goals with today's sponsor, Wealthfront. Wealthfront is an automated investment platform that uses software to find the optimal portfolio to grow your money long-term based on your risk tolerance. When you're young, you have decades of compound interest to use to your advantage, meaning that over time, your money can make you more money, which then makes you more money, and that makes you even more money. And there's decades of data out there showing that investing in a globally diversified portfolio of low-cost index index funds is one of the best ways to put your savings to work, and Wealthfront makes that process easy, accessible, and affordable no matter what your knowledge or finances. Their account setup is also incredibly simple. You just need a few minutes and $500 to open an investment account, and they will take care of the rest. They also automatically use a strategy called tax loss harvesting that could lower the taxes that you pay without any additional work on your end. And best of all, they've agreed to waive their already tiny 0.25% management fee up to the first $5,000 invested for the rest of your life. Not to mention, they also give you free access to their financial planning tools, which allow you to estimate your net worth over time and estimates how you could further save and invest more money based on your income and spending. So all you have to do to try out Wealthfront is click on the link that's on screen right now or in the description. And again, to start investing today and get Wealthfront to waive their annual management fee up to the first $5,000 for the rest of your life, click on the link that's on screen. And while you're there, click on this link for more real law reviews, or I'll see you in court. The Alabama Supreme Court ruled that embryos created through in vitro fertilization are considered living children. And the craziest thing is, they might be right. The court based its decision on the state's Fetal Personhood Amendment, which says that life begins at conception and that the state must act to protect all unborn life. Alabama voters passed the Personhood Amendment in 2018, but it was largely toothless because of the rights conferred by Roe v. Wade and Planned Parenthood v. Casey and its progeny. But when the U.S. Supreme Court overturned those decisions in Dobbs v. Jackson, it removed the guardrails. Now Alabama and other states with similar amendments can regulate women's reproductive rights in any way that they choose. And in the wake of the Alabama Supreme Court's decisions, many Alabama clinics have halted IVF procedures out of fear that, quote, patients and our physicians could be prosecuted criminally or face punitive damages for following the standards of care for IVF treatments. So patients are now in limbo. Since few insurance companies fully cover fertility treatments, many of these patients have already paid thousands of dollars for procedures that have been delayed or outright canceled. Some patients are scrambling to transfer frozen embryos to clinics out of state. And meanwhile, when a reporter asked Senator Tommy Tuberville about the decision of his state Supreme Court, he seemed to have little or no understanding of what IVF actually is.
To the Alabama Supreme Court ruling on the fact that embryos are children?
Yeah, I was all for it.
When Tuberville was told that IVF helps people have children and that some clinics have paused the procedure as a result of the ruling because they don't want to be criminally prosecuted, he says,
I thought this was the right thing to do, but
IVF is used to have more children, and right now IVF services are paused at some of the clinics in Alabama. Aren't you concerned that this could impact people who are trying to have kids?
well, that's for another conversation. People need to have, we need more kids. We need the people to have the opportunity to have kids.
Alrighty then. So today we're actually going to help the senator from Alabama by explaining the consequences of that court's decision. Now, this Alabama ruling raises many questions, such as if frozen embryos are children, then is it acceptable for them to remain on ice for decades, or do they have to be implanted into a uterus? What about embryos with genetic abnormalities? Must they remain frozen? Can they ever be discarded without charging someone with murder? What are the implications for contraceptives that prevent the implantation of an egg? If an embryo has personhood status, do child endangerment statutes apply during fertility treatments? If personhood begins from the moment a sperm meets an egg, do child support obligations begin at that moment? I'm just kidding. That would be bad for men, so that's obviously not going to be a thing. But let's start at the beginning. What is IVF? IVF starts with injecting a person with hormones to stimulate an ovary to produce multiple eggs. The eggs are collected and combined with sperm outside of the body. The eggs are placed in an incubator for about 5 days where they become embryos. The number of embryos created is unpredictable. After 5 days, the clinic assesses the embryos to decide if they're suitable for transfer into a uterus. Not all embryos fertilize normally. Some eggs do not fertilize at all, some don't fertilize normally, and some fertilized eggs have genetic abnormalities. Embryos that are good quality will be transferred into a uterus or frozen for future attempts. But this is one of the many ways in which IVF necessarily involves the destruction or discarding of some, if not all, of the fertilized embryos. And IVF treatments are expensive, between $15,000 and $20,000 per cycle. People who undergo IVF treatments sign contracts with the medical providers which dictate what should happen to their embryos. They can be frozen, donated to other people, discarded as medical waste, or used in medical research. Some of these contracts include provisions limiting the clinic's liability for loss. And what happened in one particular IVF clinic was a very unusual scenario that gave rise to this particular case. In December of 2020, a hospital patient at the Mobile Infirmary Medical Center entered an adjoining IVF storage facility through an unsecured door, removed several frozen embryos, and then dropped the embryos on the floor because of freezer burns to their hand. The embryos were destroyed. The three plaintiffs in this case were couples who had signed contracts with the IVF clinic that treated their embryos like property and waived their rights to sue the clinic. However, these plaintiffs claimed that the clinic was negligent, and as a result, their, quote, embryonic children, quote, began to slowly die. They sued the hospital and the IVF clinic for wrongful death under a separate statute. The trial court agreed with the defendants that an embryo is not a person for the purposes of wrongful death lawsuits because Alabama's homicide and wrongful death statutes define person as a human being that is, at a minimum, in utero. So one of the issues in the Alabama Supreme Court was whether a frozen embryo, which is by definition not in utero, qualifies as a child for the purposes of the Wrongful Death of a Minor Act. Now you might be asking, what about the contracts between the clinic and the patients? Wouldn't that waiver prevent them from suing under tort law? Now, typically you would expect the court to resolve that issue first, but the Alabama Supreme Court chose to discuss the issue at the end of its opinion. Quote, all the plaintiffs signed contracts with the center in which their embryonic children, we'll talk about that phrasing later, were in many respects treated as non-human property. The fund has elected their contract to automatically destroy any embryos that had remained frozen longer than 5 years. The LePages chose to donate similar embryos to medical researchers whose projects would result in the destruction of the embryos. And the ISENs agreed to allow any abnormal embryos created through IVF to be experimented on for research purposes and then discarded. The defendants contended at oral argument that these provisions are fundamentally incompatible with the plaintiff's wrongful death claims. Now, generally, courts of appeal refuse to decide complex constitutional issues if the case can be resolved on narrower grounds specific to the facts of the case. And the Alabama court admitted that in this case, it could have been decided that way. Quote, if the defendants are correct on that point, then they may be able to invoke waiver, estoppel, or similar affirmative defenses. A waiver is the voluntary relinquishment or surrender of some known right or privilege. Estoppel is the doctrine that prevents someone from arguing something or asserting a right that contradicts what they have previously said or agreed to by law. And in this case, the clinic wanted to argue that the plaintiffs entered into a contract where they agreed with the premise that the embryos were property, and the clinic then performed services based on that understanding, and now the plaintiffs can't go back and reset the terms of that relationship. However, the Supreme Court chose to delve into the personhood instead because, quote, those defenses have not been briefed and were not considered by the trial court. We will not attempt to resolve them here. In other words, the court wanted to decide the much more complicated question of whether frozen embryos are babies. Now, if you're a woman in Alabama, it looks like you're going to need a great lawyer. Yes, just in general. But my firm, the Eagle team, can help. If you've suffered from sexual harassment, were in a car crash, or were part of a data breach, especially if you got one of those data breach letters, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you don't lose your chance for a full recovery and you maximize your options. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team, so click below. So the Wrongful Death of a Minor Act in Alabama allows parents to sue for punitive damages after the wrongful death of a minor. It states, when the death of a minor child is caused by the wrongful act, omission, or negligence of any person, persons, or corporation, or the servants or agents of either the father or the mother as specified in section 6-5-390, or if the father and mother are both dead, or if they decline to commence an action or fail to do so within 6 months from the death of the minor, the personal representative of the minor may commence an action. The act was passed in 1872 when there was no such thing as IVF. Its text doesn't define children to include frozen embryos. However, the second sentence of the court's decision frames the issue this way, quote, the central question is whether the act contains an unwritten exception to the rule for extrauterine children, that is, unborn children who are located outside of a biological uterus at the time they are killed. Under existing black letter law, the answer to that question is no. The Wrongful Death of a Minor Act applies to all unborn children, regardless of their location. As the lone dissenting justice points out, none of the parties suggested that there was an unwritten exception excluding frozen embryos, because that would have assumed the definition of a child already included them. But the majority opinion immediately called frozen embryos, quote, extrauterine children, claiming that they were living in, quote, cryogenic nurseries, and then declared that they are the same thing as unborn children. And it took the majority 24 pages to explain exactly why frozen cells that look like this are the same thing as a baby. And the court relies on two sources for its decision. The 1864 Webster's Dictionary, which was in circulation at the time the Wrongful Death Act was passed, and the Supreme Court's decision in Dobbs. Webster's at the time defined child as, quote, the immediate progeny of parents. The 1864 version of the dictionary indicated that, quote, this term encompassed children in the womb, which of course does not really support the court's conclusion. But the Alabama court relied on the US Supreme Court's decision in Dobbs that in the 18th century, the unborn were widely recognized as living persons with rights and interest. Now, as an aside, that aspect of Dobbs is problematic because there are also sources of law indicating that unborn children did not have the same rights as people even after birth. But even if we accept this aspect of Dobbs as true, it still doesn't compel a conclusion that unborn indicates children outside of a uterus. However, Dobbs doesn't preclude such a finding either. Unlike the Roe case or Casey, Dobbs doesn't guarantee women any rights, including the right to an abortion. So another question is, how is a person defined at common law and in criminal statutes in Alabama? The Alabama court held that the act, quote, applies to all children without exception or limitation, and that plaintiffs' alternative claims for negligence and wantonness were moot. The court could have allowed these plaintiffs to sue for negligence on the basis that the clinic and the hospital should have had better security procedures, but that wouldn't have required the court to conclude that the embryos were children. And to reach that result, the justices had to repudiate their own precedent without expressly overruling it. The defendants argued that the definition of a person under state criminal and common law does not encompass frozen embryos. For example, in 1977, Alabama repealed its previous criminal homicide statutes and replaced them with a statute which defined the word person as, quote, a human being who had been born and was alive at the time of the homicidal act. In 2006, the state enacted the Brody Bill, which changed the definition to include fetuses in utero. Quote, the term, when referring to the victim of a criminal homicide or assault, means a human being, including an unborn child in utero at any stage of development, regardless of viability. But the majority opinion says that the textual definition of person in criminal law is irrelevant because, quote, the criminal law has always been out of step with the treatment of prenatal life in other areas of law, in that it generally prioritizes lenity towards the accused over otherwise applicable civil rights of unborn children. The opinion does not cite any Alabama law for this assertion. And the source for this statement is, of course, the U.S. Supreme Court's decision in Dobbs. Now, after the passage of the Brody Act, the court decided a case called Mack versus Carmack. In Mack, the court held unanimously that a wrongful death action can be brought when someone injures a pregnant woman, resulting in the miscarriage of her non-viable child. The Mack court noted that it would be, quote, incongruous if a defendant could be responsible criminally for the homicide of a fetal child, but would have no similar responsibility civilly. In that case, the court reaffirmed, quote, the need for congruence between the criminal law and our civil wrongful death statutes. 5 years later, the Supreme Court decided Stinnett versus Kennedy, and in that case, the court explained that, quote, borrowing the definition of a person from the Criminal Homicide Act to inform us as to who was protected under the Civil Wrongful Death Act made sense. But now the Alabama Supreme Court says that the definition of child for purposes of the Wrongful Death Act does not need to be congruent with its definition of child in criminal and civil contexts. And they might not be wrong about that. Why? Because a state Supreme Court is bound by the state's constitution. And in 2018, Alabama passed a ballot measure called the Sanctity of Unborn Life Amendment. So now Article 1 of the Alabama Constitution of 2022, quote, acknowledges, declares, and affirms that it is the public policy of the state to ensure the protection of the rights of the unborn child in all manners and measures lawful and appropriate. Now, the Alabama Personhood Amendment doesn't define unborn child. However, the court says the amendment requires the courts to err on the side of giving the unborn as many rights as possible, going so far as to call the amendment a, quote, constitutionally imposed canon of construction. Now, the sole dissent from Justice Greg Cook points out that this isn't required because neither the text of the amendment or any other authority supports such a rule of construction. And he argued that the Personhood Amendment is irrelevant to the definition of child or person. Quote, if the legislator wanted to change the words in the statute, they should have changed the words in the statute. But on the other hand, the amendment is incredibly broad, and the majority rejected Justice Cook's interpretation, holding that, quote, the upshot here is that the phrase minor child means the same thing in the wrongful death of a minor act as it does in everyday parlance, an unborn or recently born individual member of a human species from fertilization until the age of majority. But not surprisingly, the phrase from fertilization until the age of majority opens up a huge Pandora's box. Not all fertilized eggs fully implant in the uterus. In fact, between 1/3 and 1/2 of all fertilized eggs never implant. And the decision in this case would make implantation irrelevant. Under the court's opinion, if an egg is fertilized, then it is a human life, even if it is so abnormal that it would never produce pregnancy. And if that's really the case, then it really could be illegal for Alabama IVF clinics to discard any single fertilized embryo. And that's the main reason why clinics halted IVF procedures. It's functionally impossible to do IVF without discarding at least some of the embryos. Now, many have reported this opinion incorrectly, stating that the Alabama courts have made IVF illegal, leading many politicians to say that they support IVF. But that's not what happened. The Alabama courts gave blastocysts functional personhood, which makes IVF de facto impossible, just not de jure impossible. And there's an argument that child endangerment and child support statutes would apply during IVF treatments. And that's really just the tip of the iceberg. A person could also logically argue that they should be able to claim a tax credit for any embryo, though the Alabama Supreme Court rejected the idea that it should consider the policy implications of its decision. Quote, it's not the role of this court to craft a new limitation based on our own view of what is or is not wise public policy. Justice Will Sellers, who concurred in the result in part but dissented in part, accused the majority of policymaking, quote, "To equate an embryo stored in a specialized freezer with a fetus inside of a mother is engaging in an exercise of result-oriented intellectual sophistry, which I'm unwilling to entertain." And while the majority opinion is interesting enough on its own, I want to briefly touch on what Chief Justice Tom Parker said in his concurring opinion. Now, a concurring opinion doesn't carry the force of law. It's when a particular justice agrees with the outcome of the case, but wants to add in something extra. And here, the extra thing that the justice wanted to add was the Christian God, because there's just not enough of that in Alabama. The Chief Justice said that although there are plenty of legal sources affirming that the unborn are legally equivalent to people who are born, the court said it should base its opinion on authority higher than the Constitution, namely Jesus Christ and the Christian God. Quote, "But the principle itself that human life is fundamentally distinct from other forms of life and cannot be taken intentionally without justification has deep roots that reach back to the creation of man in the image of God." Genesis 1:27, King James. Quote, "Human life cannot be wrongfully destroyed without incurring the wrath of a holy capital G God, who views the destruction of capital H, his image, as an affront to capital H himself." Yes, those are sentences in a legal opinion from a Chief Justice in the United States of America in 2024. Now, in this case, the court stopped short of saying that frozen embryos have full constitutional rights. And if you want to read this decision narrowly, then all the court is saying is that for the purposes of this particular wrongful death law, frozen embryos are considered children. And we'll have to wait and see how this plays out in other Alabama cases. However, you can also read this decision more expansively and use it as precedent to argue that the destruction of any embryo that is not in utero is also criminal. And that's why clinics pause their IVF treatments, because they're concerned about civil and criminal liability. There's a huge amount of uncertainty there. And despite the personhood amendment, the person who dropped the frozen embryos in this case is not being criminally prosecuted. Probably because there's precedent that under Alabama's criminal homicide statute, the term criminal only applies to unborn children in utero. But it's also probably only a matter of time until that particular statute gets reinterpreted in light of the 2018 Personhood Amendment. But the potential for criminal charges is not theoretical. Alabama Attorney General Steve Marshall said he wouldn't arrest anyone for IVF, and Marshall previously said he would not arrest women for having an abortion, but he said he would arrest them for chemical endangerment if they used abortion medication. The state's chemical endangerment law applies to any adult who exposes children to, quote, "an environment in which controlled substances are produced or distributed." The law was intended to punish parents who expose the born, living children to harmful chemicals like drugs, but has increasingly been used to punish women who consume anything that could be harmful to a fetus, including abortion medication. Now, Alabama legislated its way into this situation, and it may try to legislate its way out of this situation. Alabama legislators are racing to create an exception to their life begins at conception rhetoric that would allow for life to be destroyed during IVF. The Alabama legislature passed a bill to protect IVF doctors from criminal prosecution. However, even if Governor Kay Ivey signs the bill, there's still many unresolved legal questions because of the constitutional amendment. State Senator Tim Melson explained it like this, quote, "We all know that conception is a big argument that it's life. I won't argue that point, but it's not going to form into a life until it's put into the uterus." Melson said in the quintessential Alabama fashion, quote, "When a lady has 2 or 3 successful pregnancies, and these are left over, it's just time to make sure that they aren't penalized for success." Now, there might be a federal legislative solution here, but I wouldn't hold my breath. In the wake of the Alabama decision, many members of Congress have reaffirmed their support for IVF, but many of those same people support the Life at Conception Act, the current version of which would establish that life begins at fertilization. That had 125 Republican supporters in the House in 2023, including Speaker of the House Mike Johnson. And that bill currently does not include an exception for IVF, though the Senate version of that bill does. But the bottom line is there's no limiting principle in the Dobbs decision that would rule out the criminalization of IVF in any particular state. In fact, one of the explicit things that Dobbs did was to allow states to create bespoke laws governing reproduction, resulting in vastly different outcomes depending on where you live. In fact, in Louisiana, a human embryo is already considered a juridical person with some rights. And as a result, IVF doctors cannot destroy embryos in that state. So if you live in Louisiana or Alabama and have a uterus, now might be a good time to scrub all information about yourself off the internet, which you can do with today's sponsor, Incogni. Incogni removes your personal data from online data brokers. Data brokers sell your info to the highest bidder, resulting in loss of privacy, phone calls, texts, spam, email, and much, much worse. But Incogni will reach out to these data brokers and make them take your personal info down. If these data brokers fight back, which I've seen them try to do, Incogni will take care of that as well. It's a great way to cut down on those annoying scam calls and emails that used to flood my voicemail and inbox and increase your privacy online. Now, we've all Googled ourselves, you can admit it. But there are major people search sites out there that have way more info about you than just your high school football stats. These sites provide in-depth records, including information such as home addresses, contact details, license plate numbers, and financial information. But Incogni gets that information down and out of the hands of scammers and identity thieves. All you have to do is give them approval to work on your behalf. Incogni conducts repeated, ongoing removals because even if the broker removes your data once, they could collect it again from a different source. But Incogni makes sure that your personal information stays off the market for good. It's fascinating for me to look at my dashboard and realize that I'm on hundreds of data brokers' lists. I feel so popular. So I guess it's no surprise why my email inbox is full of junk and my phone is constantly ringing with scam calls. Or maybe that's just Scowl Owl asking me for more hand-me-down suits. But here's my personal Incogni dashboard. It shows me that these 3 sites potentially have data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers had data including my contacts, my financial data, and health data. It's truly terrifying to see exactly how many brokers have data on me, but it's really fun to watch Incogni get them to delete that info one by one. So if online privacy is important to you, give Incogni a try. You can click on the link below to get 60% off Incogni when you use the code LegalEagle. Again, to get an exclusive 60% off discount, just click on the link that's on screen right now or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court.